Farris.
Thank you, Madam Deputy Speaker. I want to begin by talking about Amendment 2, which removes the retroactivity provisions that says that the bill will apply to anyone who arrived on or after the 7th of March 2023, which is the date it was introduced in the House. There is a good reason, in general terms, why we do not allow legislation to apply retrospectively, so that there is legal certainty and people are only bound by the obligations that apply at the time. I accept without reservation that the law would be in disarray, for example, if new criminal offences had retrospective effect and people found themselves criminalised for things that they could not possibly have known to be unlawful at the time. But in my respectful submission, I think that this is not that kind of point. There is no principled argument to be made. First of all, the government made clear at the date the bill was introduced that was the same date it would become effective. Secondly, a person cannot argue in any compelling way that they decided to make an illegal crossing to the United Kingdom in March because they believe they might end up in a hotel in Southampton, but now they know they might have ended up going to Rwanda. They would not have made the same illegal crossing. I'm afraid that argument doesn't work at all. And I accept the government's position that the only way that this policy will have the desired deterrent effect is if it has retrospective effect, and so that we do not create perverse incentives for people smugglers to surge to the crossings immediately before it receives royal assent. The second tranche of amendments are those that were identified by my Right Honourable friend, the Immigration Minister, as wrecking amendments, Amendments 1, 7, 90 and 93, and I'll deal with them collectively. Amendment 7 seeks to strike out Clause 41D, which says that removal should take effect irrespective of whether or not there's a judicial review application. Amendment 90 seeks to strike out Clause 52, which says that interim orders may not halt deportation. And Amendment 93 seeks to strike out removal pending an age verification appeal. There is a wider point to be made about these amendments. Collectively, they seek to dilute the deterrent effect of all the removal provisions. Whatever we disagree on in this chamber concerning current migration, there is one point on which we probably can achieve a consensus. It is a situation that is not going to get any easier to resolve, and whether the UNHCR is correct in saying that there are 100 million displaced people or whether it's tens of millions, the reality is that famine and climate change and flooding and conflict are going to bring more and more people leaving their own countries of origin and trying to come elsewhere. If any nation state is going to try and resolve this situation within its own domestic arrangements, then it has to follow a strategy which is very similar to the one that the government is pursuing. The first element of that strategy is to decide upon a cap for admissions and then, likely with UNHCR support in the future, give proper consideration in advance as to who should come under that quota scheme. The current schemes, which are working very well in relation to the Ukraine, Afghanistan and Hong Kong, provide a very good starting point for all of that. But the second element is to deter all illegal migration by ensuring that, with only the narrowest of exceptions, an individual gains absolutely nothing from doing so. So the objective of the illegal migration bill, and by extension the Rwanda scheme, is to remove illegal immigrants quickly, without prejudice to their wider right to challenge the deportation order later, because the rationale is that speedy deportation deters others from coming to this country. And there are many eminent people who agree with that proposition. As the former Supreme Court Justice Lord Sumption said in his foreword to Professor Eakin's recent paper for Policy Exchange, the objective is frustrated if deportees are able to hold up their removal for years while their challenge goes through potentially 3 tiers of appeal, followed by a petition to Strasbourg. The process commonly takes years. Whatever one thinks of the Rwanda scheme, if interim measures are available in cases like this, then it is probable that no legislative scheme for the prompt removal of illegal migrants could ever succeed. I will.
The Honourable Lady is making a well-made argument, and she's right about those amendments from the Lords which are designed to undermine the principle and practice of this bill. Would she extend her very sensible suggestion that the safe and legal routes recommended by various people across the chamber need to be capped, applies to legal migration too. For we cannot continue to grow our population to the tune of 600,000 a year without placing unbearable pressure on our public services, making the provision of housing impossible and changing the face of our country forever.
Well, I thank my honourable friend for that intervention, and if I could come back on 2 points. First of all, on the face of the bill, there are going to be annual quotas that it'll be decided upon with the consent of various local authorities who will be responsible for accommodating those people, and I think that's the right approach. And on illegal migration, no, I don't think that people arriving through irregular routes should take precedent over those who will be arriving lawfully through the safe and legal routes. And I think we could not allow a system where one displaces the right of the other, and I think that's a feature of this bill. The second thing that I wanted to say was about the effect of judicial reviews, which is, I think, what's it's Amendment 7, which is seeking to sort of permit judicial reviews. And actually, I cannot improve on the language that was used by David Blunkett when he was Home Secretary, when he was introducing Labour's flagship immigration bill, the Nationality, Immigration and Asylum Act 2002, which was supported actually at the time by the Shadow Home Secretary. He said at second reading, and I wanted to refresh my memory because I thought it was a powerful part of his speech, at the moment, the system is virtually unworkable. People can bring a judicial review during the process of the initial appeal, and when they reach the right to appeal to the tribunal, they can judicially review the tribunal for not allowing the appeal to the tribunal. They can then judicially review the tribunal's decision, and they can then judicially review whether they are entitled to go to the Court of Appeal following failure at the tribunal. The whole system is riddled with delay, prevarication, and in some cases deliberate disruption of the appeals process. They can judicially review the decision on removal even when all appeal rights have been gone through. Now, we have simplified the system a bit since then, but effectively he is right. He was right then to seek to effect removal before, after one right of appeal had been exhausted, and I think the government is right now to aim for swift removal without judicial review holding everything up. And then the final point, Madam Deputy Speaker, very briefly. I took from the speech of the former Supreme Court Justice Lord Browne, who spoke at second reading of this bill in the Lords. He sat as a crossbench peer and he died on Friday. And he said this: "No doubt the bill can be improved in various ways, but we must recognise that almost every amendment we make to soften it can only tend to weaken its essential objective of stopping the boats. We must give the government the opportunity by this bill to confront this most intractable of problems."